In October 2020, the Right to Disconnect Advisory Committee began meeting regularly. Its mission? To provide recommendations to Canada's federal government on supporting their workers' work-life balance and well-being. I'm Rebecca Jackson, a lawyer at Labour Rights Law. After the video, if you have any questions about your work-from-home arrangement, please give us a call for a free 30-minute consultation over Zoom. Our contact information can be found below. Labour Rights Law encourages employers and employees to ensure that their work-from-home arrangements not only follow the law, but are capable of providing employees with the support they need to stay healthy and well. To guide employers and employees toward this goal, we discuss a number of legal issues that may arise from working from home below. Under employment standards legislation, employers are required to pay employees overtime wages if they work more than the limits set out by the law. In BC, qualifying employees are paid time and a half for any time worked over 8 hours in a day, up to 12 hours, and paid double time for any time worked over 12 hours in a day. Employees in BC are also paid time and a half for any time worked over 40 hours in a week. These overtime thresholds include time spent working from home after a full workday. Employees who answer emails from their employer regularly beyond their normal working hours, or are prompted by their employer to do additional tasks after a full workday, are generally owed overtime unless they are managers or are specifically exempt. In BC, overtime wages are due under the Employment Standards Act when an employer allows, directly or indirectly, an employee to work overtime. Typically, the obligation to keep track of overtime hours worked by an employee rests with the employer, not the employee. However, we encourage employees to keep an accurate record of their hours worked in the event that they need to submit a complaint for overtime pay through the complaint process provided under the employment standards legislation. An adjudicator evaluating the employee's claim for overtime pay will make findings of facts based on the evidence available. So records of hours worked, email trails, or records kept on electronic devices will help an employee succeed in his or her overtime claim. Employers may also breach hours of work provisions under employment standards legislation if employees are required to spend excessive time on their mobile devices or doing remote work at all hours from home. In BC, the Employment Standards Act states that an employer must not require, directly or indirectly allow an employee to work excessive hours or hours detrimental to an employee's health or safety. Employers should always provide support to employees who come to them with a reasonable belief that working excessive hours is having a negative impact on their health. In every Canadian jurisdiction, it is against the law for employers to discriminate against employees based on prohibited grounds in applicable human rights statutes. These prohibited grounds include family status and mental disability. Working excessive hours from home or being required to answer emails or text messages any time during the day and evening might be more difficult or even impossible for some employees. For example, an employee who has dependent children might not be able to respond to emails from work because the employee is taking care of their kids. Employees with diagnosed mental illnesses such as anxiety or depression may not be able to tolerate around-the-clock availability. Employers who refuse to accommodate these employees up to the point of undue hardship could face complaints at human rights tribunals. Every employer must ensure the health and safety of all workers working for them. If workers are working from home, then that duty extends to the workers' homes. At a minimum, employers should have policies in place that require employees to do risk assessments of injury in their workspaces at home and how to report hazards and injuries. Workers should also have a safe workstation that does not introduce ergonomic hazards. These include workstations with monitors that are too low or too high, or chairs that aren't built for sitting in for 7.5 hours a day. Workers can make claims for compensation with workers' compensation tribunals for injuries that arise out of and in the course of employment. Although some employers may not turn their minds to it, this includes injuries that happen while working from home. For example, repetitive stress injuries workers suffer from home are compensable, including claims caused by bad makeshift workstations in their homes. If employees are working from home and on the go, the question of whether or not the injury arises out of and in the course of employment can become harder to answer. Before the pandemic, the question of whether or not the injury happened on an employer's premises was often an important factor when adjudicators considered the connection between the injury and the worker's employment. If workers are required or expected to do something from outside of the office, then, depending on the injury and its connection to employment, an injury occurring at home or elsewhere may more likely to be compensable. Thank you for watching our video on important legal issues in work-from-home arrangements. If you're a Canadian and you have questions regarding your work arrangements, please give us a call or contact us at the link below. At Labour Rights Law, we offer free half-hour consultations in person, over the telephone, or over Zoom.